Judiciary is the third important organ of government which has responsible to the maintenance of law and order. Maintenance of law and order. What are the functions of a judiciary? What are the functions of judiciary in India? First, judiciary is responsible to maintain law and order. First, as to maintain law and order. Second, judiciary is responsible to resolve the disputes which are arising in between of two state governments, either state government or a central government, between the citizens and the government. Citizens and the government. Such disputes are sorted out by the judiciary. Third, judiciary is punished the guilty on the basis of the proofs, witnesses. On the basis of available proofs and witnesses, judiciary it punished the guilty. Accused is a state when the crime has not proved against of that particular individual. The person it will be known as accused. When a crime it will prove with the help of available witnesses and the proofs, then that will known as the guilty. Now the Supreme Court or a judiciary, the different levels of the courts, it punished the guilty. It has given as a punishment to the guilty. Next, fourth function of the judiciary is the advisory. It has given the advice to the President of India. Supreme Court, the Chief Justice of India, has also advised to the President in a different administrative matters. For example, the emergency situations. In a state of emergency, the Chief Justice of India, it can suggest to the President of India for the emergency situations. So as the advisory function of the Supreme Court. Next is the judiciary has issued writs. Judiciary has issued writs. What are the writs? Writs are the orders. Supreme Court issued the orders in relation to the functioning of those organizations, in relation or against to the functioning of those organizations which are violate those organizations which are violate the rights of individuals. Under such circumstances, the judiciary has passed the writ. WRITS. Writs means stay order. Writs, it can be as a pass by the judiciary against of those authorities which are responsible for the violation of the rights of citizens. Violation of rights of citizens. Clear? So this is as the fifth function of a judiciary. Sixth function of a judiciary is a reviews. Judiciary is responsible for the review the hearings, the court hearings or the cases which earlier as sorted out by the lower courts, it has again reviewed in a higher courts. Next one, seventh is judiciary is also reviewing the law structure. If the law which has implements by the executives, not followed by the people, under such circumstances, law can return towards the assembly, towards the Lok Sabha or the Rajya Sabha for reconsideration. Clear? Now the eighth function of a judiciary is the judiciary protects the fundamental rights of the citizens. Till there any questions? Next one is the judicial structure in India. In India, the judicial structure has generally worked through the three-tier structure. Three-tier structure. In which as the first apex court as a Supreme Court, second Supreme Court, second high courts, and third subordinate courts. Clear? There are three levels of the courts are there. Supreme Court, one Supreme Court is there. Supreme Court is there, which has located at the center, at the national level in Delhi. Second is the there are the high courts are there. Total number of 23 high courts are present in the capitals of the states. 23 means the northeastern states are having as a collective one high court located in Guwahati. Punjab, Haryana having the common high court, except these number of states. Rest of all the states of India are having their own high courts. They are possessing their own high courts, which has located at their capitals. Clear? Located at their capitals. Next one, there are the subordinate courts are there, which are responsible for the maintenance of law and order in different provinces, in districts of India. So subordinate courts are divided into the civil courts, criminal courts, lok adalats, consumer forums, revenue courts, etc. Civil courts, criminal courts, lok adalats. Lok adalat is a way which has introduced for a speedy justice or to resolve the pending cases, those cases which are pending since last 30-40 years in a courts. For this as a lok adalats. These are not a permanent in nature. They are temporarily as organized by the judiciary. Lok adalats. PIL is also one of the way for a speedy justice, in which as those issues are raised which are associated with the mass population, public interest litigation. Consumer forums are there. These forums are located at the central level, at state level, and district level. Consumer forums are protected the consumers from the exploitation by shopkeepers and producers. Exploitation in the sense, if a good has produced, it has purchased by the consumer, that particular good has not properly functioned. Under such circumstances, it's a duty, responsibility of a producer is that they have to maintain that particular good which sold it to the consumer under the warranty period. If the producer refuses to maintain or replace as the good, under such circumstances, a consumer can go towards a consumer forums, consumer courts. Clear? So these are the three levels of the courts. Let me start from the first, Supreme Court. Supreme Court is the apex court of India, which has located in Delhi. It is present in Delhi. It has a certain functions. The functions of a Supreme Court are original jurisdiction. Jurisdiction means such matters which has related or introduced. They can has introduced in relation to the violation of a law. It is known as a jurisdiction. When situations are discussed, these are sorted out related with the violation of a law is known as a jurisdiction. Jurisdiction. So there are three jurisdictions. The three important parts of the Supreme Court are original jurisdiction. What it means? Certain number of the cases are there which can directly introduce in a Supreme Court, neither introduce in a subordinate or nor in a high courts. These can directly introduce in a Supreme Court. What kind of cases? First, violation of a fundamental rights. If the fundamental right of any of an individual in India are violated by the authorities, by the organization, by the individuals, then a case will directly introduce in Supreme Court. That case will introduce in Supreme Court. Clear? That case will directly introduce in Supreme Court. Second one, if there is a dispute has arising in between of two states, between of two state governments related with the water disputes, boundary areas, under such circumstances, there will be as a Supreme Court will interfere. It will be sorted out of such matters. Clear? Original jurisdiction. Till there, any questions? Till there, any questions? Next is a appellate jurisdiction. Appellate means the term comes from appeal. The matter which is sorted out by the lower courts, either by the subordinate courts or high courts. That matter, the case related with that matter, it can be appeal in a Supreme Court directly. The case, जो case पहले sort out किया गया है by the subordinate courts or a high courts, that case it can reintroduce in a Supreme Court. We can appeal. A person can appeal towards the Supreme Court. First, appellate jurisdiction means to review the cases of a lower courts. To review the cases of lower courts. Second, review the cases of itself. Means that case which earlier introduced in Supreme Court given as the verdict. Under such circumstances, a person can again appeal in a Supreme Court. There is no limit. A person can appeal in a Supreme Court for the many number of times. Yes, advisory jurisdiction of Supreme Court. Supreme Court has the Chief Justice of India has also advised to the President of India in various issues. For example, in a situation of an emergency, if the country has not properly administered, if India has not properly administered by the central government, or either the state governments fail to administration in India, under such circumstances, the Chief Justice of India, it will advise to the Supreme Court, advise to the President for emergency or President rule. Clear? Advisory. Second is if the President has not functioned properly, if the President of India has not works properly, it is inefficient. Under such circumstances, it can be also removed from their post. It can also remove from their post by the advice of the Chief Justice of India. Chief Justice of India. Navkaran, what we call to that process? Manmeet, what we call to that process in which President can remove from their post. Police, it can't directly arrest the President. First of all, the President will remove from their position. That position is the President of India. Then afterwards, the case will file against that particular individual. For example, if the Prime Minister, any of a Chief Minister not function properly, first of all, it will be removed from their post. My question is what we call to that process through which the President can remove from their position. President, it can be removed from their position. What we call to that process? Impeachment. That process is an impeachment. Process is known as the impeachment. 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 I-M-P-E-A-C-H-M-E-N-T. Impeachment. If the Chief Justice of India consider the President has not worked according to the constitutional framework, according to the Constitution. Under such circumstances, the joint session of a Lok Sabha and a Rajya Sabha, it will be called by the Speaker of a Lok Sabha. Joint session, people will cast as a representatives of Indians. They will cast their votes in favor or against of the president. If the majority favors against of the president, under such circumstances, president, first of all, it will remove from their post. Then they may, as a case, will file against of him or her in a Supreme Court. Clear? This is as the advisory role of a Supreme Court. Till there, any questions? First, as the original jurisdiction, cases directly introduced in a Supreme Court. Second is the appellate jurisdiction, cases sorted out by the lower courts, it can appeal in a Supreme Court. Third is the advisory jurisdiction. Any questions related with this? Those who are having any queries, they can ask. Otherwise, we will proceed towards the next court, high courts. High courts. High courts are present in a state level. State level. High courts. So each and every state, it has possessed their own high court, which has located at their capitals. The functions of high courts are original jurisdiction and appellate jurisdiction. High courts are not related with the advisory jurisdiction. Original jurisdiction means the cases related with the cases which are related with the breaking of a law in a state. Well, directly, it can also directly introduce in a high court, or either whereas a citizen has a dispute with the state government, it can also introduce in a high courts. It can also introduce in high courts. Appellate jurisdiction, the proceedings of a lower courts, the cases sorted out by the lower courts can appeal in a high courts. It can appeal towards the high courts. Clear? It can appeal towards the high courts. Next is the subordinate courts are there. Such courts which are located at a district level. District level. These are the subordinate courts. These are also known as a district courts. District courts. District courts, session courts, civil courts, criminal courts, etc. Now the next question has arisen here. What's the difference between as a civil and a criminal cases? Civil law, criminal law. What is the difference between the civil and the criminal law? The first difference between the criminal and the civil law is a criminal law has deals with the offenses that are committed against of the society. That are committed against of society. Clear? That are committed against of society. Whereas a civil law has generally resolves the disputes between the various individuals and organizations. Civil law deals with the disputes related with various organizations and individuals. Second, the criminal law punishes the convicts. It punishes the convicts, protects the citizens, and ensure to maintain the law and order. Criminal law punishes the convicts and protects the citizens and maintain law and order in India. Law and order in a state. Whereas the civil law is to protect the rights of an individual. Civil law protects the rights of an individual or organization. Second difference done. Third difference, the criminal law, in these cases, the court is empowered, charge a fine, imprison. It can charge a fine. Second, as it can imprison the guilty. Guilty that person against of which as a case proved. It will imprison the guilty or discharge the defendant. Discharge the defendant. I mean to say it can as a penalty in a form of currency. Rupees की penalty लग सकती, fine लग सकता है. It can be a person sent behind the bars or both. Fine and punishment. Fine and imprisonment, both it can be as a possible. Clear? In civil cases, civil law, the court in such cases only pass the judgment to compensate for damage. It can only give the judgment to compensate for damage. For example, Ram and Sham both had a fighting. After the fight, Ram is seriously injured. Seriously injured. On such cases, the Sham, it will be as a compensate, it will pay as all the expenses which are spent by the Ram for the medical, all compensations. Clear? Civil cases, civil law, it can only pass the judgment to compensate for damage done to the by the accused. Damage done by the accused. Clear? Fourth difference, criminal cases. In criminal cases, the accused is prosecuted in the court of law. The accused is prosecuted in the law, in the court of law. In a criminal law, the accused against of which as a crime has not proved. Accused is prosecuted. The case will present from the side of the accused by the prosecutor, public prosecutor. If there is a situation in which as a Ram has murdered the Sham. Ram murdered the Sham. Under such circumstances, the Ram not having a money to which it can hire a lawyer. Under such circumstances, court will provide as a public prosecutor a lawyer free of cost, which will defend the accused. It will defend the accused. Clear? In the other side of civil cases, civil law, the victim or the organization, victim against of which the crime has happened. Crime happened. So Sham beaten the Ram. So crime happened against of the Ram. So the victim can also offend itself. Victim can offend itself. Victim, it can offend itself. Next is the fourth difference. If the accused is found guilty, then court will send him or her against the bars. If it will imprisoned by the guilty will imprisoned by the court. Next, as the civil courts, civil law, the court gives the specific relief. Court, it can gives the specific relief in a cases where the opponent demand for the relaxation of the other. Clear? Fifth difference, criminal cases are lodged on the basis of FIR, First Information Report. Criminal cases are filed on the behalf of the FIR. FIR is what? This is as a first information report which has filed by the police station, filed at a police station by the station in charge on the basis of the statement given by the witness. On the basis of a statement given by the witness. Witness will give, it will tell about what incident occur, who are engaged in that particular crime. that particular crime. Clear? On the behalf of the FIR, police, it will file as a charge sheet. Charge sheet means how many or which of the law are break by that particular accused. Clear? So on the basis of the charge sheet, the case will introduce in a civil courts. In the other side, the criminal courts. On the behalf of the FIR, case will introduce in a criminal courts. Whereas in a civil law, civil courts, a petition has to be filed before the relevant court by the affected party only. Affected party only. Clear? Then 6 says the examples: murder, theft, dowry, harassing a women, eve teasing are convicted under the criminal law, whereas the civil law includes the rent matters, revenue, divorce, purchase of goods, etc. Purchase of goods, etc. Clear? These are the differences in between.